Welcome and thank you for being here. Whether you're brand new to the profession or simply looking to sharpen your skills, you've landed in exactly the right place. Today, we're diving into one of the most critical topics every notary must understand: what you can notarize, and just as importantly, what you absolutely cannot. Because knowing the difference isn't just good practice, it protects you, your clients, and the entire integrity of the notarial act. So let's get started. Today I'm going to go over 10 most frequent requested documents for notarization. Why does this matter? Great question. First, let me paint a picture. Every single day, notaries across the country are faced with documents and situations that test the limits of their authority. And here's the thing: a mistake in either direction can have serious consequences. Notarizing something you shouldn't, that's potential liability. Refusing something you legally can notarize, that's failing your client. So today we're going to walk through both sides of the coin clearly, methodically, and with real-world context. Keep in mind, by the end of this presentation, you'll walk away with a complete roadmap of your notarial authority. First, let's talk about the power of attorney, one of the most powerful and frequently requested documents you'll encounter. Why does this one top the list? Because a POA can transfer enormous authority from one person to another. The power to manage bank accounts, sell property, or even make medical decisions. Next, you need to confirm identity with a valid government-issued photo ID and ensure the signer is fully aware of what they're granting. Keep in mind, your job is not to give legal advice about what the POA says. Your role is to verify identity, witness the signature, and complete your notarial certificate accurately. Next up, affidavits. Now here's a document that carries real legal weight. An affidavit is essentially a person putting their word in writing under oath. So why does the notary matter here? Because your seal and signature transform that statement into a legally recognized sworn declaration. First, you administer the oath or affirmation. This is a required verbal step most notaries sometimes rush through, and you should never skip it. Next, witness the signer's signature. Keep in mind, if a signer refuses to swear or affirm, you cannot complete the notarization. Real estate documents, and this is where many notaries do the bulk of their business. We're talking deeds, mortgage papers, closing documents, and refinance packages. First, understand that in real estate, errors have financial consequences. A missing signature or incorrect notarization can delay or even void a closing. Next, each document in a package may require its own notarial act, so pay close attention to each page. Keep in mind, as a notary, you are witnessing and certifying signatures, not advising on the terms of the agreement. Stay in your lane, and you'll be an asset to every closing table. Number 4, bills of sale and vehicle title transfers. These two go hand in hand, and they are incredibly common in everyday notary work. First, a bill of sale documents the transfer of personal property, from cars and boats to equipment and furniture. Next, vehicle title transfers specifically handle the legal change of ownership for motor vehicles. Why does this matter? Because without proper notarization, the DMV may reject the paperwork entirely, leaving both buyer and seller in a frustrating limbo. Keep in mind, always verify the ID matches the name on the document before you pick up that seal. This one is so important. Parental consent forms for traveling minors. First, let's understand the stakes. These forms protect children from abduction and unauthorized travel across borders. Immigration and border officials take these documents very seriously. Next, when you notarize a consent form, you're confirming that the signing parent or guardian is who they say they are and that they are willingly authorizing the travel. Keep in mind, this is a document with real child safety implications. Accuracy is non-negotiable. Always verify the ID of the consenting parent, and make sure the document is fully completed before you notarize. Medical authorization forms, and these can be life or death documents. First, understand that these forms allow one person to step in and make critical healthcare decisions when someone cannot speak for themselves. Next, they also authorize access to sensitive medical records, which is governed under strict privacy laws. Why does this matter? Because a properly notarized medical authorization can be the difference between timely care and a medical crisis. Keep in mind, the signer must appear competent and willing. If anything feels off, if they seem confused, pressured, or unsure, you have not only the right, but the responsibility to pause the notarization. Contracts and agreements, the backbone of business. First, not all contracts require notarization, but when they do, your seal adds a powerful layer of credibility and legal protection. Next, common examples include lease agreements, business partnership contracts, and service agreements. Here's a question worth asking. What does notarization actually do for a contract? It deters fraud by confirming the identities of the signers and documenting that they signed willingly. Keep in mind, you are not a party to the agreement, and you should never read or interpret the terms for the signers. Your focus is purely on the identity and the signature. Loan documents, and yes, this overlaps with real estate sometimes, but private and personal loans deserve their own spotlight. First, loan documents establish a legal financial obligation between parties, and notarization helps ensure that obligation is properly recorded. Next, private loan agreements between friends, family members, or business partners especially benefit from notarization because it adds enforceability. Keep in mind, just as with any financial document, confirm full completion before notarizing. A loan document with blank spaces is a document you should not touch, trusts and estate planning documents. And this category is where precision really matters. First, state laws vary significantly on which estate documents require notarization versus witness signatures. So always know your state's requirements. Next, living trusts, advance directives, and certain wills may all land on your desk. Why does this matter so deeply? Because these documents govern what happens to a person's assets and medical wishes after they can no longer speak for themselves. Keep in mind, just because a document is titled Last Will and Testament does not automatically mean it needs notarization in your state. When in doubt, advise the client to consult an attorney. And rounding out our top 10 general business and legal documents, which covers a wide variety of notarial acts. First, you may be asked to perform acknowledgments, jurats, copy certifications, and signature witnessing across dozens of document types. Next, these can include everything from financial affidavits to business license applications. Keep in mind, the type of notarial act required is determined by the document or the requesting party, not by you. Your job is to perform the act correctly, not to choose which act to use. When you're unsure, ask the requesting party to clarify what type of notarial act the document requires. Now let's make this real. Here's what an actual notarial certificate looks like for a power of attorney, and I've tagged every field so you know exactly what goes where. First, look at the state and county fields. These reflect where you are commissioned, not necessarily where the signer lives. Next, the date field captures when the notarial act actually occurred. Keep in mind the signer's name must match exactly what appears on their government-issued ID, and your signature, seal, and commission expiration must all be accurate and clearly legible. One missing element can invalidate the entire notarization. These tags are your roadmap to getting it right every single time. Let's shift gears because knowing what you cannot notarize is just as critical. First on the list, incomplete documents. Here's a question. What's the harm in notarizing a document with a few blank lines? The answer is everything. Those blank spaces can be filled in after the fact to completely change the document's intent. Next, a notarized document carries the presumption that it was complete and authentic at the time of signing. Keep in mind, if a signer pushes back and insists it's fine, that's your signal to hold firm. Politely but clearly explain that you cannot notarize an incomplete document, and offer to assist once it's fully filled out. Number 2, and this is a fundamental rule of notarization, the signer must be present. First, let's be clear. The entire purpose of a notary is to verify identity and witness a signature in real time. If the signer isn't there, you cannot fulfill that duty. Next, the only exception is remote online notarization, RON, which is now legal in many states, including Tennessee, under specific conditions. Keep in mind, someone bringing you a document and saying, "My spouse already signed this, can you just notarize it?" is asking you to break the law. Never do it. Not for family, not for friends, not for anyone. No ID, no notarization. It's that simple, and here's why. First, your primary duty as a notary is to verify identity. If you cannot confirm who the signer is, you are certifying nothing. Next, acceptable IDs typically include driver's licenses, passports, and state-issued ID cards. Keep in mind, expired IDs are generally not acceptable, and you should never bend this rule out of convenience or sympathy. If someone forgot their ID, the notarization has to wait. The integrity of the entire system depends on this step. And yes, your commission can be revoked if you notarize without proper identification. Trust your gut and trust your training. If something feels wrong, that feeling is your professional judgment speaking. First, watch for signs of coercion. Is someone else answering for the signer? Is the signer nervous or hesitant? Are they being pressured? Next, look for signs of confusion. Does the signer know what document they're signing? Can they explain the general purpose of it? Keep in mind, you don't have to prove fraud to refuse. Reasonable suspicion is enough. Politely decline. Document your reason and move on. You are the last line of defense against document fraud. This one surprises many new notaries, but no, you cannot notarize a birth certificate, marriage certificate, or death certificate. First, let's understand why. These documents are official government records, already certified by the issuing agency. A notary's seal adds nothing legally and can actually create confusion. Next, what you can do is notarize a copy certification affidavit, a sworn statement by the document holder confirming the copy is accurate. Keep in mind, if a client needs a certified copy of a vital record, they need to contact the issuing government agency, not their notary. This one comes with a serious legal warning. First, there is a major and dangerous misconception in some communities that notario means immigration attorney. In many Latin American countries, a notario is a legal professional, but in the United States, a notary public is not. Next, providing legal advice on immigration forms, even with good intentions, constitutes unauthorized practice of law. Keep in mind, the consequences can be devastating. Clients can be deported or denied legal status based on incorrect forms. Your responsibility is to witness and verify signatures only. Always refer clients with immigration legal questions to a licensed immigration attorney or an accredited representative. Conflict of interest, and this rule protects your integrity. First, if you stand to financially gain or lose from a document you're notarizing, your impartiality is compromised. This includes being a named beneficiary in a will you're notarizing, or having a stake in a business contract you're signing off on. Next, even if you feel you can be objective, the law in most states does not allow it, and for good reason. Keep in mind, your seal represents neutrality. The moment you have a personal stake, that neutrality disappears. When in doubt, refer the client to another notary. The signer must understand what they are signing, full stop. First, mental competency is a legal prerequisite for any valid contract or legal document. If a person is confused, unable to communicate clearly, under the influence, or in extreme distress, their signature may be legally void. Next, as the notary, you are the one making the judgment call in the moment. Ask simple questions. Do you understand what this document is? Are you signing this of your own free will? Keep in mind, this protects you as much as it protects the signer. If the signing is ever challenged in court, you want to be confident that you used good judgment. State law matters here, and this is one area where notaries absolutely must know their specific state's regulations. First, copy certifications are not permitted for public records in many states. Why? Because official copies of public records must be obtained from the originating government office. Next, this includes deeds on file at the county recorder's office, court records, and other recorded documents. Keep in mind, if a client asks you to certify a copy of a court order, deed, or other public record, you need to know your state law before saying yes. In Tennessee, for example, there are specific restrictions on what notaries can and cannot certify. And finally, know your jurisdiction, know your limits. First, your notary commission is state-specific. You are authorized to perform notarial acts only within the boundaries of your commission state, and only according to that state's laws. Next, if you move to another state, travel frequently, or plan to offer services across state lines, you will need to research whether your commission covers those scenarios, and in most cases, you'll need a new commission in that state. Keep in mind the laws governing notaries vary significantly. What's permissible in one state may be prohibited in another. When in doubt, consult your state's notary handbook or the Secretary of State's office. Stay informed, stay compliant, and protect your commission. Let's bring it all home with the golden rules every notary should know by heart. First, verify identity every single time. No shortcuts, no exceptions, no matter how much you think you know the person. Next, never notarize incomplete documents. That blank space is a trap waiting to be sprung. Keep in mind, the signer must be physically present. unless you're operating under an authorized remote online notarization platform. And here's a reminder that frees many notaries from unnecessary worry. You are not responsible for the contents of the document. Your responsibility is the signature, the identity, and the notarial act. Finally, trust your instincts. If something feels wrong, you have every right to decline. Protect your commission, protect your clients, and protect the integrity of this profession. And that's a wrap on today's lesson. You now have a clear professional understanding of the most popular 10 documents you can notarize and the 10 you cannot, along with the reasons why each rule exists. Remember, every time you place your seal on a document, you are making a promise of integrity. You are confirming that identity was verified, that the signer appeared willingly, and that everything was done properly. That matters. That protects people. And that's exactly why the notary profession is so important. If this video helped you, please like, comment, and share it with a fellow notary or someone considering the profession. Subscribe to this channel for more resources just like this one, because knowledge is the most powerful tool in your notary bag. Until next time, stay professional, stay informed, and keep serving your community with excellence.